Yes, so thank you for that wonderful introduction. I'd like to thank Mika, who's a batchmate of mine, as well as Lawyers Hub for providing me with this opportunity and to provide the students of Kyle with this platform where they can interact with their peers. Now, I'll be displaying a PPT, so I'm sure that will aid us more in understanding about mooting. Let me just quickly display it. It's visible, right?
Yes.
So let's talk about moot court. So a lot of us might be once before we thought about joining law college. I know about myself. We all wanted to get when we look at the idea of a court or of joining law, we often naturally seem to think of it as litigation, basically presenting ourselves before a court, before a judge. Of course, a lot of us eventually incline towards corporate law as well. But mooting is something that will really help you all if you are planning to get into litigation. Yes, there are differences between how a real court works and how a moot court works, but with respect to the critical thinking skills that you develop, with respect to how you learn how to draft the language of a particular draft, whether it's a writ petition, whether it's an SLP, not the format, but the language of the draft, or whether it is about the confidence that you need to speak in front of a judge, the confidence that you need to stand there and to be grilled by the judge in front of you and still come up with answers, still argue your point. I feel like all of this is really important, and mooting has taught me how to deal with all of this. Eventually, all of you who are probably in your first years, or others who are in second, third, and fourth years, fifth year students, we've all been to court once or twice in our lives, right? During internships. So the way that we are supposed to present ourselves there in the future, or the way that we are supposed to draft a petition, the way that we are supposed to think like a lawyer, mooting really helps us with that. At least it has helped me with that. Also, for the people who are young law schoolers, for instance, the first and second year students, I would urge you all to go out ahead and start mooting from now onwards. Do not wait till your final year, do not wait till your penultimate year or your fourth year basically to start mooting, because the earlier you start, the more experience, the more traction that you gain, the better you will be able to perform, right? So let's begin. What is mooting? Let's understand what mooting is in the first place. So you might be seeing this picture in front of you. Let me just explain. This is what mooting looks like. At least the semi-final or final rounds of a moot court, if you've ever witnessed one, if you've ever participated in one, this is how it looks like. This bench that you see, the three people sitting here, these are the judges. Three judges are generally part of the final rounds. This table that you see, this is called the podium. Here is where the petitioner and respondent advocates eventually come and present their arguments towards the judges. And this is the audience which is sitting behind. So let's understand what is a moot court. A moot court is basically a court hearing, as you can read here. It's a court hearing. It's a mock court hearing in which participants, they analyze a particular legal problem. They research upon relevant laws, statutes, precedents. They prepare written submissions and present an oral argument before the judges. Basically, what mooting does, it trains you to think or anticipate what the judges will ask you, what questions will be asked by the judges to you. Generally, the research problem or the moot court problem that is given to students in national level moot court competitions at least is a writ petition, or it's a special leave petition. Writ petition under Article 32 generally, which goes before the Supreme Court, or it's an SLP under Article 136. So these are two major kinds of problems. So basically, you are supposed to deal with fundamental rights in Part 3 of the Constitution. So for mooting, especially at the national level, you need to have a very good hold upon Part 3, and you have to have a very good hold upon constitutional law. Right? So let's see, let's go ahead. One more thing before I go ahead is with respect to moot court, one of the most important things is the team that you form. So for people who have still not formed a specific consistent team for moot court, now is the time to go out ahead and find a team. A moot court team comprises of two speakers and a researcher. The two speakers are supposed to deliver the oral argument, while the researcher is supposed to... Is there a question? Okay. So the researcher is supposed to draft the memo. The researcher is supposed to aid with the research part of it all. So make sure that you have a good consistent team of hardworking individuals. Even if you do not have a knack for legal analytical thinking at the moment, you will develop it. But at least have a bunch of people who are passionate towards litigation, passionate towards mooting. Now let's go ahead. Anatomy of a
voice is not clear, it seems.
Okay. Am I audible now?
Yeah, it's good now.
It's good now. Okay. Yes. Sorry for the little snag. Alright, anatomy of a moot. So, what is the skeleton of a moot court? What are the 5 main things that you have to focus upon if you are going for a moot court? First is your jurisdiction. As I said, it is generally a writ petition under Article 32, very rarely under 226 because 226 is before the High Court. And secondly, it is either a special leave petition, which is under Article 136. Now, for your jurisdiction, you have to be very clear with respect to which article are you going ahead with, which is generally mentioned within the moot court problem itself. You have to be very sort of precise in identifying the same. For instance, you need to know the fact that Article 32 is your fundamental right, which means you have the full fundamental right to approach the Supreme Court itself under Article 32, whereas Article 136 is not a right at all. It is merely a discretionary measure. When you go to the Supreme Court under a special leave petition under Article 136, it is the Supreme Court's discretion whether or not it wants to entertain your petition. So that is after you list down what is the jurisdiction that you fall under, that is when you will be able to frame your argument. That is when you will be able to properly tell the court why is it that you have a locus standi, why is it that it is relevant for you to stand there and take up the court's time. Secondly, let's talk about facts. So any moot court proposition that you have is basically nothing but a gist of facts that is given to you. A gist of facts given to you, what I would suggest is what I do as well. It's a little old school habit, but it always works out. Is take a pen and paper, sit with the moot court problem that is at hand, and list down all the important sort of criteria out of that problem. For an instance, what is the name of the parties? What is the jurisdiction under which you're approaching the court? Which court are you approaching? Which date did the dispute occur? What is the nature of the dispute? Is there any prior pre-litigation measures which have been taken? So basically the entire summary of that moot court problem should be known to you by hand, and it should be known to you by heart. You should be able to speak it, you should be able to know it, because only when you know it is when you can draft any argument properly, right? So if there is any sort of a timeline that is given within facts, generally the facts of a dispute, so before a dispute, whenever facts are presented, they're across a different timeline. For an instance, it starts from 2014 and it ends in 2020 with a case being filed. So what is the timeline? Note down the timeline, pinpoint which event occurred, so that you know what is it to be argued before the court and what are the answers that you are supposed to give to the court. Thirdly, issues. So a lot of students are from Kyle, they might know that when you look at intra-moot court propositions of our college, a lot of times issues are not provided. That is because they want the students to critically think and analyze and come up with issues on their own. Contrary to that, in a national moot court competition as well as international moot court competitions, issues are given to the students already, so that there is a uniformity with respect to the argument that is presented by the students. When an issue is given to you, the most important thing is to analyze what is given within the issue, to dissect the issue, to understand what is it that the judge expects you to argue out of that. So understand the issue first, argue on those lines, and you are of course free within the drafting part of it, which I will address later on. You are of course free to cut down the issue into different sub issues as well as sub issues, and then speak about them eventually, right? And my advice would be to stick upon those issues, because these are questions of law that have been determined by the court, because generally any sort of a moot court is a final hearing. It is the final hearing, so the issues have been predetermined by the court. So stick to those issues, do not change them. Then arguments advanced. Arguments advanced are nothing but your written submissions, or it's also known as the memo that you submit before the court. You have to submit it in national moot courts as well as international moot courts. You are supposed to submit it from both sides, from the petitioner's side as well as from the respondent side. So there are 2 memos that you are supposed to prepare. Generally, with respect to the arguments advanced, you have been given, every single organizing college gives you a set number of pages within which your moot court has to be, the moot court memo has to fulfill the set amount of pages. So make sure you do not cross those number of pages. I will be speaking about drafting under arguments advanced later on as well, but this is the crux of it. Then lastly, when you talk about the last part of it is the prayer. Now a lot of times as law students, even I have made the same mistake during my initial years, is we tend to ignore a prayer just because it falls at the end of a moot court memo. We do not pay much heed to it. We pay a lot of heed to arguments advanced in the cases we cite, but we do not generally pay a lot of attention to prayer. So let me tell you, prayer is the most important thing, because when you are going before a court, if the court asks you in total, leave all of your arguments aside, what is it that you want? If you mess up in the prayer that you're making before the court, you have already lost 90% of your mooting right there. You have to be very clear as to what you want from the court. Is the court even viable? Is it sustainable legally for the court to provide you with that relief or not? I will also be talking about prayer eventually later on. So let's wait till then. But this is the anatomy of a moot, the skeleton, the crux that you are supposed to know. Alright? Next. Now let's talk about research work. So I think mooting mein, the most important part is, apart from the written part of it, is the backhand, whatever goes behind the curtain, behind the scenes. What goes on behind the scenes is nothing but the research work. However, how strong you are in your research work, that is how well drafted your memo will be, that is how well presented you will be before the judges, and that is how much impressed the judges would be with your work. Right? Research speaks volumes. It speaks a lot more than you think that it does. So I have sort of divided research work, what are the important research works, into three different sources. Let's look at them one by one. First of all is the Constitution of India. So the Constitution of India is of course the grand norm. It is the very law of the land upon which everything is based, upon which all of our statutes rest. I would just like to go ahead and present the Constitution of India for those who do not have an idea of it at the moment. So just a moment, I'll just show you how it looks like, which part are you supposed to deal with during a moot court, and so on and so forth. Yes, so this is the Constitution of India. This is how it looks like. You can always have a pocket copy of it as well, which is a physical copy of it. Otherwise, you can have it in this sort of a document. This is how it looks like, right? It's written down in English as well as in Hindi. So as I said, the most important part of it is part 3, which is fundamental rights. So anytime that you need to refer to fundamental rights within your problems, anytime that fundamental rights are mentioned within your writ petition, the first thing that you are supposed to do is come to the text, come to the very precise text of the Constitution. It stretches from Article 12 onwards. Read through whichever is the relevant, suppose it is whichever is the relevant article, suppose it's Article 14, read through it, suppose it's Article 15, read through it. First, you read through this, and that is when I would urge you to go ahead and read some sort of an article or some sort of a blog with respect to it. So that at least you know what is the very crux of it, what is the main content that has been drafted in the law itself. Alright? Now let's go back to the PPT once more. So the Constitution, as we have determined already, this is the first preliminary source that you will refer to, at least in a writ petition as well as within a special leave petition. Right, now I hope it's visible, the PPT again. Right, now the second preliminary source is a BEAR Act. Now BEAR Act generally looks something like this. Right, you all must have seen it. It's either it's by different publication houses. This one's by the professionals. The one that's displayed on the screen is also by the professionals. The BEAR Act is basically the statute. It is the statute upon which you are fighting a particular case. So generally what happens in writ petitions and special leave petitions is that a particular statute is questioned altogether. So it is said that a particular statute is in contravention to the Constitution of India. So in order to determine whether or not it's in contradiction to the Constitution of India, whether it is violative of the Constitution of India, you will have to read through the statute. Of course, you don't have to go through all the hundreds and 500s pages of the entire statute. You have to go through the relevant sections which are again mentioned within the very moot court problem. Thirdly, let's look at this. So all of you law students must recognize this building by now, I'm sure. And if you don't, you need to do a little bit more of a research, because this is the Supreme Court of India. The Supreme Court of India gives out precedents, and the precedents that it gives out are binding upon lower courts. So a lot of times, I'm sure a lot of law students already know about this, that precedents are an important preliminary source. But what we tend to overlook a lot of the times is the fact that what sort of precedents are binding, and what sort of the things that judges say within judgments are binding or not binding, right? For an instance, You are supposed to know the difference as a law student between a ratio decidendi and an obiter dicta. You are supposed to know the difference between a reportable judgment and a non-reportable judgment. So, for instance, what is a ratio decidendi? A ratio decidendi is the very principle of the judgment, the principle which the court decides. So, suppose there's an issue before the court, whatever the court decides with respect to that issue and that issue itself, that forms a part of your ratio decidendi. And ratio decidendi is what is binding upon lower courts. Obiter dicta by the Supreme Court, or any court for that matter of fact, is nothing but a judge's opinion. I think a lot of you, if you follow live law and pages such as those, you must have listened to a lot of obiter dicta being stated by Justice B.V. Nagaratna. For instance, she spoke about the Sabrimala verdict as well. She spoke about certain moral policing aspects as well. So those are not part of the judgment. Those are not binding upon the lower courts in any single way at all. Do not cite obiter dicta in your drafts. Do not cite that within your memos. Only cite the ratio decidendi within your memos. Secondly, as I said, the difference between reportable and non-reportable judgments. Reportable judgments, so whenever you open a particular judgment, right, you will be able to see whether or not it's reportable, because it's written at the very head of the judgment, whether or not it's reportable. And on the very first page, it's mentioned whether it's reportable, whether it's non-reportable. If it is reportable, that means that it is dealing with a fresh principle, and it is not already settled facts of law that it is debating about. It's a very fresh principle of law that the judgment is dealing about, and thereby it is binding not just upon the parties before it, but upon everybody else, basically all lower courts and all cases. In contradiction to that, when you look at a non-reportable judgment, that is nothing but when only already settled facts are resettled by the Supreme Court. Right, so these judgments, unless and until they overturn the previous few judgments, these are not binding upon everybody. They have a persuasive value, yes, but they are not binding upon every other lower court that is in question. Also, another thing is, so I'll just go ahead and I will share one other slide with you guys, which I really wanted to show you. So just a moment. Right. Yes. So as I said, right, this is a judgment that I have opened. This is a Supreme Court judgment, and I would suggest that one more thing: when you are trying to download Supreme Court judgments, do not use Lawbhumi or Loctopus or all these websites, or Law Kanun and all those websites to download judgments or to refer to judgments, because these are not reliable sites. Just type in within Google that such and such case, for example, State of Punjab versus Davinder Singh Supreme Court case PDF, and I'm sure within the first few results you will find a PDF that is shared by the Supreme Court itself. So only trust those PDFs and only refer to those PDFs. Right, so as you can see, this is the front page. It's already stated here that it's a reportable judgment. So this is a judgment that you can quip, that you can use an excerpt from within the memorial. So generally this is how the front page looks like. This is the name of the petitioners, this is the name of the respondents, so on and so forth. Another very important thing with respect to precedents is, firstly, yes, of course, you can speak about the fact that there are what the judges said and what the judges held within the judgment. That is, of course, very, very important. But secondly, if you are stuck while drafting an argument, if you are stuck while looking at a particular legal issue and you do not know what other way can you debate this issue, then the best way is to find a case law from which the problem has been inspired, because 99 out of 100 times the problems that you get in national and international moot courts are largely inspired by pre-decided cases. Right, so find out a case like that. You will often stumble into a case like that. Find out that case, recognize that case, open the PDF, and generally most Supreme Court cases have an index. So this is the index basically, right? It mentions which page contains which sort of a content. Herein you will find a submissions block within which you can see submission of petitioners and submission of respondents. These are basically the two sides which are arguing. So now if I'm stuck from the side of petitioners and I do not know what kind of an argument am I supposed to make, I can just quickly open the Supreme Court case PDF and I can see what are the submissions made by the original petitioners therein. Right? So I can see that Mr. Gurminder Singh, for instance, Advocate General for the State of Punjab, and Mr. Shadan Farasat made such and such submissions. So there will be multiple submissions. There will be pages and pages of submissions, wherein if you have a writer's block and you are not able to think of a new argument altogether, you can always refer back to the original arguments that were made. And within a judgment, within most judgments, at least the contemporary, the newer judgments, I'm not talking about judgments of 1950 or 1960, so on and so forth, but latest judgments, at least all of them since the past 10, 20 years, all of them will have this index, and all of them will give you arguments that were stated by the petitioner as well as which were stated by the respondent. So make sure you read through the same before you start drafting. Okay. Right. So this is with respect to the preliminary sources. Now let's move on to the second kind of sources. What are certain secondary sources that we have at hand? This is all as you all can read. It's the Black's Law Dictionary. So there are certain dictionaries which the Supreme Court of India as well as other courts rely upon for definitions. A lot of the time certain terms are not precisely defined within any act. For an instance, maybe a term such as marriage, it might not be defined under any act, for an instance, right? So where do you go to see it? You go to the Black's Law Dictionary, of course the latest edition of it all. So Black's Law Dictionary is honestly the most heavily relied upon dictionary in terms of definitions, which the Supreme Court as well uses. So you can use the same. Secondly, as you can see, this is a case commentary. This is a legal commentary. So there are different legal luminaries, legal experts who will take up a particular law, for instance Hindu law in this case, and they will write an entire commentary upon it, which is nothing but an entire book upon what the law is, how it originated, much more than the bare act. They will talk about precedents with respect to it. They will talk about arguments with respect to certain issues which have fundamentally been raised about the law. Both sides, the petitioner side, the respondent side, they will talk about other customs and practices with respect to that law enforced. So it's a very, very helpful tool that you can use within your memorandum, especially when you have time and you read it on it. You will find a lot of points to argue and to put in within your drafting. Thirdly, journals. When you look at law journals, you can always go ahead to Google Scholar. You can always type in any particular topic. Suppose you want to read about trans rights, you can write transgender rights amendment bill, and you will find hundreds of different research papers that people have written. And you can often open those research papers wherein scholars, eminent legal scholars, have written these research papers. So they are law students, these are PhD holders, masters holders from very, very prestigious universities. These people have written these research papers after a lot of research. So they have incorporated, again, just as in the commentaries, they have incorporated case laws, they have incorporated different arguments, different points, different instances which have happened with respect to that law. So you can incorporate all of that as well within your research. It's very important so that you have a multifarious research. You're not just limited to one sort of a thing. And also it's important to note that a lot of times we tend to have the misconception that if we do not have the subscription to SCC or to Manupatra or to JSTOR or any of these other sites which might require money as well, we are not going to be able to do research properly. That's a total misconception. I do not have any sort of a subscription into any of these things. Yes, our college has an SCC subscription, but I use that very, very rarely. So even when you do not have a subscription, it is not that you cannot do a moot. It is not that you cannot perform research at all. You can do it. It is available for free. You just need to know how to Google it and what to Google and what to use. That is the only thing that's important. Now let's look at other sources. So you can see this is one of the most famous logos that we all have to recognize because we use it the most probably on a daily basis, ChatGPT. Now, ChatGPT or any other sort of an AI. Now, let me make it clear, I am not against the use of AI for moot court propositions at all, because I think it is a very, very efficient tool. It's a very time-saving tool, but you need to know how to use it. You cannot go ahead and use it, for the lack of a better word, stupidly, or you cannot go ahead and use it in a very lazy manner, wherein you type in a prompt that give me an argument for so and so, and it gives you an argument and you simply copy and paste it. That's the worst way that you can use AI, right? If you want to use it in a genuine, helpful fashion, the way to do it is use AI to narrow down your research. For an instance, I want to research about, again, as we already took an example, transgender rights, right? I have a moot court proposition with respect to that, whether or not the transgender bill, now the transgender act, whether or not it is unconstitutional, whether it violates the fundamental rights of the citizens or not. Suppose I want to research this. I want to make a memo from the petitioner side first. I go ahead to ChatGPT and I type it out. For instance, case laws with respect to transgender rights within India, the past 50 years, or the past 10 or 20 years. by the Supreme Court, and you give in the prompt, it will give you a list of different case laws with a crux or with a summary of the facts within each of those cases. You can always read that, refer to it, and then don't stop at that. Do not just copy paste that. Go to the Supreme Court site, see the case which ChatGPT suggests to you, open up that case, use Control F, read the relevant portion of the judgment, and then see whether or not the judgment is relevant or not. If the judgment becomes relevant, you can use that judgment, use the copy paste the part of that very judgment and then paste it within your drafting, within your memorial. And if it is not relevant, then you go ahead to a different judgment that ChatGPT suggests. So basically all it does is it narrows down your work. If you just type it into Google that Supreme Court cases with respect to transgender rights, it will maybe give you hundreds and thousands of pages that you will have to go through, that you will have to sift through. And not necessarily all of these pages will also give you a summary of what the cases entail or what are the facts of the cases. But if you ask ChatGPT to do it, it will give you a list of 10-20 cases which are very important, which are sort of landmark judgment with respect to it, and it will also give you facts of those cases. You always have to cross check it. There is absolutely no question. You have to cross check it, but the fact is you have to use ChatGPT in a way that it really reduces the amount of hard work that you do, and you can sort of replace it with smart work. Next, we have this. This is a constitutional bench. It is, I think, it's a 9-judge bench, 7 or 9-judge bench. This is also from the Supreme Court as well. Now, when you look at a constitutional law bench, what this image wants to reflect to you guys is the fact that another source which you can use for mooting is case hearings. So a lot of times in Supreme Court, whenever any case is being argued, I remember researching for the Navteej Singh Johar case, which was about LGBTQ rights. The case hearings are often posted on YouTube. It is maybe not the entire case hearing at hand, but clips of it are always posted on YouTube by some or the other YouTuber, or some or the other page always posts it. If you go ahead and you have identified the case from which the Moot court problem is inspired, you go on ahead to YouTube, you type out that case, and if it's a famous case, generally it's always there. The YouTube links are always available for that. You go ahead, you open it, you just listen to it. It may be 15-20 minutes at end. Listen to that part and see how the people or how the advocates are arguing. How is the Solicitor General arguing, for an instance? How is the petitioner's lawyer arguing, for an instance? Understand how they are arguing, understand what are the points that they are making. Also see what are the questions that the judges are asking, because those are Supreme Court judges. They think on a very different level than we can think about, right? So they are asking certain very relevant legal questions. Go through that, and that's how you will be able to enhance yourself and prepare yourself as to what you will have to say when the responding party says something to you in a rebuttal, or when the judge asks you a question. How are you supposed to respond to this question? How are you supposed to argue? If you are stuck in an argument, what next argument are you supposed to make in this regard? All of it is pretty much available online for free. So do use it. Do completely exploit the resources that are available to you for free. Next. Now let's look at drafting, right? What is drafting and how important it is? So now when we look at drafts, there are certain important things that we need to keep into consideration again. A draft, as I said, is, I think I've mentioned before, it is nothing but the memorandum that you are submitting. So the same language that you use for a moot court memo, I'm not saying the format is the same for real life court issues, but the language is the same. The way that you critically think and the way that you draft a problem, the way that you perceive a problem is similar in both of those instances, right? So let's see what are the things that you need to keep in mind for this. First is you need to have a command over language. Most of the moot courts, 99% of moot courts that you will do will be in the English language. You have to have enough command over the English language that you are able to understand what the facts of the issue, what are the facts, what are the issues, what is the moot court problem, and most importantly, what is it exactly that you are writing. You cannot mention any word at all before you know its meaning, whatever it is. The golden rule of drafting is know what you are drafting, even if it is in the simplest language ever. Do not use complex words, do not use words that are too heavy, too big, do not use them. Use the simplest form of language, but have command over language, have command over grammar, because a single comma or a single full stop changes the entire meaning of the sentence. And if the meaning of the sentence is changed, your entire submission, the crux of the submission is lost if the meaning gets changed. So do not make that mistake. Have a good command over, at least over what you are writing and what you are presenting before the court. Secondly, dissect and understand the issue at hand. Whatever is the issue at hand, whatever issues have been provided to you, understand the issue first of all. What is the issue asking you to do? That's very important, because whenever a judge is sitting there, they will look at the fact that is this person able to perceive the issue or not? Do they know what they are arguing or not? And secondly, then dissect that issue. So divide that issue among different sub issues. You can suppose it's issue number 1. You can divide it into sub issue 1, then sub issue 1.1.1, so on and so forth, as many as you require to set across a point. But yes, only do it if it's necessary. Do not unnecessarily add material to your memo just to complete the word count, because that will be of no use at all. Thirdly, incorporate relevant precedents. While drafting, make sure you have to basically keep in tandem 3 things: law, fact, and precedents. You have to make sure that all these 3 things are juggling together. You are connecting law with precedents, and law and precedents with facts of the current case. Right? So all these things cannot be in 3 different directions. They all have to come together, merge finally to present one single output to the judge. Okay. Fourthly, critically analyze statutory provisions and right of constitutional framework. Now, it's important to understand that we are going before the judiciary. The job of the judiciary is to interpret, right? That's an interpretative body. So even when you are presenting something, what is mooting or what is litigation? It is basically presenting your interpretation of something and hoping that the judge, or convincing that the judge agrees to your interpretation rather than the interpretation of the other person on the other side of the podium. Right? So feel free to interpret a statute according to what the facts are, according to what the law is. Right? Take that creative liberty, have that thing in your mind where you can go beyond traditional bookish thinking. You can think beyond that, and you can actually critically analyze a statute. Right? Associated with the constitution, associated with the fundamental rights which are mentioned within the constitution, and then come up with it. Then lastly, you have to highlight rights. If any of your rights are getting violated, or if it's alleged that you are violating certain rights, you have to make sure that you know what those rights are. You have to make sure you know the difference. Again, basics, right? You need to know the difference between fundamental rights, constitutional rights, and legal rights. You have to know what happens when each of these are violated. What is the consequence when fundamental rights are violated? I know that I can go to the Supreme Court under Article 32. I know that if the state violates it, again, even under fundamental rights, if an individual violates it, if a private individual violates it, I cannot access my right under Article 32. So I need to know all of these things. I need to know what is a constitutional right. I need to know how is it different from a fundamental right, or what is a legal right altogether, and what are the remedies that are available to me upon the violation of all of these rights. For the students who have not yet studied constitutional law, you will be studying it soon, I'm sure, and constitutional law 1 as well as constitutional law 2. So whenever you are studying these subjects, make sure that you think accordingly and you ask these relevant questions when you have a doubt, because the smallest of differences make the biggest of changes. Right? Because it might seem like different rights, categories of different rights, is something very small and you do not really need to pay much attention to them. But the truth is, everything makes a difference. Every single small word that you use makes a difference, which is why, again, as I said, you have to have command over your language. Alright. Now let's move ahead. Actually, before I do this, let me just show you guys a draft of the memo that I had created for one of my previous Moot Court competitions, so that you guys just know how is a flow of a particular Moot Court memo supposed to be like, right? Just a minute. Yes. So this is a Moot Court problem. Okay, I'll just display this very quickly. This is a Moot Court problem. Moot proposition, the petitioner as well as the respondents. These are the petitioners and these are the respondents. Now let's look at it. This is generally a concoction of all facts that will be at hand. What is the dispute? How did the dispute occur? What were the parties to the dispute? It will look something like this. And then in the end, they will be giving you the issues raised. For instance, something like this. Right? This is a list of all the issues that are raised. Then I will go ahead and I will see in a lot of these moot courts there might be annexures as well, which are different statutes that they have created. So these are statutes that do not exist in real life. These are statutes that they have created. So you have to go through these statutes as well. Now let's go on to the part that I wanted to display, which is a moot court memorial. So this is a memorial for the respondents, which is why it is red in color. This is how the front page should look like. right? You have got the article under which you are coming. So it's the writ petition. As you can see, it's a writ petition of a civil nature of the year 2024. You've got the name of your petitioners, you've got the name of your respondents. You say here that it's a memorial on behalf of the respondents. Then you go ahead, and these are all certain formalities that you have to complete within a memo. This is a statement of jurisdiction. Here is when you will be telling the court as to what is the jurisdiction with which you have approached the court. As you can see, it's 32 hearing. Then statement of facts. As I said, while writing down facts, make sure that you are writing down what are the parties to the dispute, what is the background to the dispute, what is the dispute itself, what is the resultant litigation. Note all of it down. Now let's come to the most important part, which I said is the argument advance and the prayer. So this is the argument advance, right? I will be writing down the issue herein. What am I trying to say with the issue? What is my side of the story? That's what the issue will be interpreted as and written over here, not the question mark format. Then we go ahead and we see that there is a sub issue herein that we have created. Then we go ahead below and we see a sub issue that has been created, right? So that is how we are able to dissect all parts of it. So it looks somewhat like this. There comes sub issue 1.2, then 1.2.1, so on and so forth. Now let me take you guys to the prayer just to show you how it looks like. This is what a prayer looks like. It's the very last page of your memorial, but the most important page, right? So this is what it will look like. This is just to give you an idea of what a moot court memo looks like, in case some of you have not been to any national moot at all. It's just to show you what is the extent to which you are supposed to write, or what is the extent to which you are supposed to dissect a particular issue, right? So now let's come back to the PPT. Alright. Now we see on the screen certain figures that have inspired a lot of us to come to law school. At least they have inspired me to come to law school. You see Harvey Specter, you see Saul Goodman, Annalise Keating, Mike Ross, Jessica, and all these people. So when you look at these people, what is the one thing that comes to your mind? What is the one thing that they have achieved, or what is the one thing that how they present themselves that you are so attracted, or that you are so interested in what they speak? What is it at the end of the day? It is cadence. It is the way that they speak. It is the way that they modulate their voices. It is the way that they're able to grab control of the entire room just by speaking even a single line or two lines, right? Now, with that, let's come to how to build an oral argument. Oral argument is nothing but, again, as how I said, how do you attract the attention of the entire room towards yourself? When you go ahead with an oral argument, there's certain time difference. Once you submit your memorial, you have a few days till the starting date of the competition, wherein you are supposed to build an oral argument, and then you're supposed to go ahead and present it. I would suggest to all of you, do not speak merely from the memorandum. Create a separate document of 5-6 pages which entails the crux of your memorandum or your issues that you are dealing with, and that is your oral argument. Oral arguments are nothing but a competition of pure dominance. You are supposed to go there and you are supposed to make sure that the eyes of the entire room and the ears of the entire room are on you. You're supposed to make sure that when you walk out of that room after the competition is done, it is you who leaves a mark on the mind of the judges, on the mind of the respondents, on the mind of the other party, on the mind of everybody present in that room. This should be your aim within an oral argument. This and this alone. Now, there are certain things that will aid you to do the same. First and foremost thing that you have to keep in mind are the etiquettes. So etiquettes are basically a composition of a lot of things. How do you dress? How do you address the bench? How do you address your opponents? How do you greet your opponents? How do you stand? What is the tone of your voice? How do you speak? All of this forms part of your etiquettes. Right? You have to make sure. Now, etiquettes are the most basic thing ever. These are the easiest ways in which you can get marks, because I think some 10 or 20 marks are already allocated for etiquettes. If you are messing up etiquettes as well, then there is really no point of you doing a moot, because it's the easiest 20 marks of your life that you will ever get. So make sure, if nothing at all, at least you are in good etiquette, right? Secondly, saturate the written submissions content. Now, when you are saturating the content, make sure that you write it the way that you would want to listen to somebody speak. Now, when I'm writing down something, if I have to read it, it's much different. It is going to occupy my attention much differently than speaking will occupy my attention, right? So when I'm speaking, it should sort of be like a speech. It should be something that is very enticing, something that is really calling the listener to listen to it, right? You use voice modulation, you use quotes, you use different sort of metaphors, synonyms, etc., so on and so forth, whatever you require to make sure that the judge sitting there is not bored. You have to make sure that the judge sitting there is looking at you and listening to you. One of the most important ways to do it is, a lot of times students, they submit the memorandum, and the judge has the memorandum and they speak, but the judge does not even look at the memorandum. The judge is merely either looking at them, or the judge is not able to pay attention because of how boring the speech is at the end of the day, because judges are also human beings. Let's be very clear about this. What is the best way to do it is keep the judge engaged. How would you keep them engaged? Mention page numbers of memorandums. Tell the judge, please go to this page of the memorandum, please refer to that page of the memorandum. If you've submitted a compendium to the judges, the compendium, for those who don't know, is merely nothing but a set of cases that you have cited, printouts of different cases that you have cited. Tell them to refer to flag number so and so of the compendium. Tell them to refer to page number so and so of the memorandum. Keep the judge occupied. Keep the judge with you. They should be in tandem to the argument that you are making. Thirdly, focus on time-bound submissions. You are generally given in a moot court competition 20 minutes of time to speak, you alongside your co-speaker, because there are two speakers. Now you can divide this time as you like. It can be either 12 minutes and 8 minutes, it can be 10 minutes and 10 minutes, or anything that you would want to finish both of your issues properly, right? Whatever time is being given to you, there will be a there will be a clerk sitting there, a court clerk sitting there, who will show you 5 minutes left, 2 minutes left, and when time is over, they will show you that as well. Make sure there should be a reflex action embedded among each one of you, that when the timer ends, when the court clerk shows up the sign that time is over, you have to immediately stop whatever you are saying and you have to ask the court for more time. 30 seconds of your time, 1 minute of the court's time maximum. Do not ask for 5 minutes, do not ask for 2 minutes, 5 minutes, 10 minutes of the court's time. How much ever of your argument is remaining. Maybe you can ask 30 seconds later, you can ask again for 30 seconds, or you can ask again for 1 minute of time. That is fine. Judges will generally grant that. They will ask you to wrap it up soon, but they will be granting that. 5-10 minutes, nobody is going to grant you, because in a real court setup as well, it is very difficult to take the court's attention span for so long in the process of an ordinary hearing, unless the judgment is reserved for a later time, wherein one entire hour is just reserved for the judgment, right? Make sure it's time bound, because if you do not ask for time from the judge, then you will be losing marks. If the judge allows you to speak for 30 more seconds or 1 more minute, that's when you will not lose the marks. But if the judge has not allowed you and you are still going on and on and on, they will cut your marks for that, which is also another easiest way to lose marks. So do not do that. Then fourth, creative liberties in cadence, leave a mark. As I said, the way that you speak, how do you modulate your voice, what metaphors do you use, what synonyms do you use, what similes do you use, do you quote or not, how do you present yourselves, how do you move your hands around, so on and so forth. All of these things are creative liberties that are to be taken by you to make sure that the judge is enticed, that the judge is interested in what you are speaking. And last but not the least, the story that you present has to be a tightly bound story. Now, when you look at the written submission that you are submitting, one thing that you have to note is that the written submission that you're submitting can have a little bit of a leeway. They can be a little loosely bound, right? So that you have enough time when you're preparing for oral arguments to make it more tightly bound. Because if you have a very tightly bound written submission, a lot of times it might be a little problematic to prove that particular point within court. Or you might realize after you submitted a memo, it happens a lot of times, more often than you guys know, that you submit a memo, then you realize the point that you made about law within the memo is wrong. So now what happens in an oral argument? You cannot say the wrong law before the judge, because you know that the judge will grill you. So what do? You sort of twist it. You interpret it differently. The written submissions, your own written submissions, you interpret them differently. And how do you do that? If you leave a little bit of leeway in your written submissions. But when you're presenting an oral argument, it has to be a very clear-cut, sharp, precisely drawn, tight-bound story that you're presenting before the judge. It has to be a picture-perfect story. Now let's go to the next slide. Prayer. Now, coming to prayer, what you want. As I said that I will be elaborating upon prayer later, this is when I will be elaborating upon it. Prayer is basically nothing but what is the relief that you seek from the court. The first and foremost thing in a writ petition is to know your writs. You are supposed to know which one of the 5 writs are you asking for from the court, whether it's habeas corpus, whether it's mandamus, certiorari, prohibitio, quo warranto, whatever it is, because the judge will ask you that, okay, You have come before us under Article 32, and you are saying that you have a locus standi, which means you are able, you are one of the parties affected by the particular dispute at hand. But which writ do you want us to pass? Under which writ do you want us to pass an order? So, or pass a judgment. So you need to know which writ you are coming to before the court. You need to know each of these writs. Again, a lot of us might have already studied it in constitutional law. For those of us who have not studied it, you will have constitutional law as a subject. Understand very clearly what are the different writs. Secondly, you have to know what you have to ask for relief on the lines of arguments advanced. You cannot argue A and then ask for Z relief. You have to have your prayer in tandem to the arguments that you have made before the court. Alright. Thirdly, whether the relief sought is viable to be provided by the court or not. And fourthly, the difference between powers of High Court, Supreme Court, Executive and Legislature. These 2 points are very closely connected. So whenever you're talking about the relief that you want, you have to make sure that the court is eligible to provide you with that relief. Now, let's understand one thing: the Supreme Court or the High Court cannot give you everything on God's green earth. You cannot ask for anything and hope that they will just pass an order. For an instance, you cannot ask the Supreme Court to pass an act. You cannot ask the Supreme Court to pass a legislation. You cannot say that. You cannot ask the Supreme Court or the High Court to direct the President to do something. That is not the power that is vested with the court. You have to understand what are the powers vested with the court. Only then can you demand for something. Because if all of your arguments are correct, if everything is right, but in the prayer you ask for something that the court cannot grant you, there is no use of the arguments that you have advanced, because all of that goes down the drain now, right? Then also you need to know the difference between High Court, Supreme Court, Executive and Legislature. You need to know what the High Court can do, what the Supreme Court can do, what the executive body can do and what the legislative body can do. A lot of times when you will be arguing from the side of the state in a writ petition, one of the most common arguments that I have also made and I have seen being made is the fact that, my lords, the issue at hand is the prerogative of the legislature and not of the judiciary, which means that the state is stating that the issue at hand is not something that the court is even eligible to look at. It is something that is completely falls under the eligibility of the legislature, which means the parliament at hand. Thereby, the court cannot pass an order with respect to this, and the case has to be dismissed. So keep this in mind. And lastly, but a very important thing, do not contradict among relief sought via different prayers. A lot of times what we do is we try to put in a lot of prayers together so that the memo looks full, and then we contradict among different prayers themselves, right? For an instance, I'll show you an example. Now, for an instance, I'm praying that declare that the state lacks statutory authority to regulate a particular X body. And then the next prayer is, alternatively, hold that the state exercise such authority arbitrarily. So I have to make up my mind at that point of time whether I want that the state has any authority, or whether I want to say that the state has no authority over it, or whether I want to say that the state has authority but it has exercised authority in this case arbitrarily. What is it that I'm wanting to see? I can only have one clear view. I cannot have different principles that I will ask 10 different things. The court will at least grant me one of these, and all of these are contradictory to each other. I cannot do that. Second example is declare that no legal relationship exists between the parties at hand. And then I ask simultaneously to enforce certain obligations arising from such a relationship. Now, if there's no legal relationship, if I'm praying that there's no legal relationship between parties, how can I ask to enforce any sort of an obligation which arises out of that very legal relationship? So I have to make sure that I know the difference between the two. Similarly, the last of these, for an instance, set aside the order for lack of jurisdiction and correct the errors apparent on the face of the record. Now, I cannot tell the court that first of all you do not have the jurisdiction to deal with it, and secondly you also correct any errors which are within this particular petition at hand. I cannot say that, because if the court does not have jurisdiction, the court cannot do anything beyond dismissing the case further on, right? So we have to keep that in mind, and we have to be very considerate of this fact. Next, how do we handle judges' questions? This is sort of a make it or break it thing. This is an instance where you'll gain a lot of brownie points. If you are good, if the judge likes you, you will be gaining a lot of brownie points. Now, let's look at a few pointers for this. First of all is perception of the judge. You have to perceive the judge. The second that you go before the podium, you have to perceive what kind of a person the judge is. There are different kinds of judges. For example, certain judges will be quiet during the entire round that you're speaking. They will not ask you a single question at all. They will just be quiet. It is your job to engage them. It is your job to ask them again and again, my lord, is there any question? Or my lady, is there any question? Is there anything that the council can sort of help the court with? Is there anything? Can you please refer to this page of the memorandum or this page of the compendium, so on and so forth. Your sort of responsibility to do that. Second kind of judges will be judges who are always prodding. The second that you start speaking, they will have a question. The second that you start speaking, they will have a question. They will not let you speak. The way to handle these judges is simply to stop talking. Stop talking, let them ask a question, only answer in 1 or 2 lines as to what they are asking. Only ask in 1 or 2 lines, only answer 1 or 2 lines what they're asking. As simple as that. They have no interest in listening to your entire memorandum. They do not want to listen to your issues. They just want to see whether or not you are able to take the grilling that they are providing to you, whether or not you are able to handle such a harsh level of grilling or not. That's what they want to see. You prove it to them and they will be happy. They will get out of your hair. Third kind of judges are judges who want to always display their knowledge, who want to speak about the issue at hand. Right? These are the kind of judges who will not ask you questions. They will deliver sort of a lecture within it. Now, whenever you are coming across such a judge, again, do not take it upon your ego that the judge is only speaking, they're not letting me speak even though I have prepared so much. It might be so that you have prepared a lot. But at that point of time, you require marks from the judge. You do not need anything else from the judge. So just be quiet, handle the judge, whatever they have stated, re-quote that to them and said that as the honorable bench rightly pointed out to so and so, the council is making such and such point in tandem to that. So go ahead, do that. Use your brain, use your critical analytical thinking skills there. Understand how to perceive a particular person, because the perceiving of a judge is the most important thing. Right? Is the most important thing. Now, secondly, when you look at it, is confidence is key. Even if you're standing there and you do not know something, do not feel underconfident, do not feel that you do not know something very big, because the second that you lose confidence, you will start stammering, you will start fumbling, you will start losing all control that you have over that situation, and you will not be able to deliver a proper issue at hand. Even if you mess up right in the first line, do not lose your confidence. Speak, even if you need false confidence, speak from false confidence, because that reflects, and that is also one of the marking criteria. The way that you present yourself is one of the most important marking criteria that there are. Now, thirdly, overconfidence is a big no. A lot of times what we do is, even if we do not know what we are arguing, or even if the judge asks a question and we do not know it, we go ahead and we answer it as if we know it. And we sort of take up that particular word that we have at hand and we speak it up from our mind, despite knowing anything about it. So do not do that, because the smallest of errors within a moot court, the smallest of divergence from one topic to another, can prod the judge to take your issue from a criminal matter to a civil matter. They will start questioning you on that line now, and you have completely lost the track of everything else, because the judge's job is there to grill you, and they are grilling you and you are sort of not able to handle it, which is why you are just going the way that they want you to go. They are not asking questions the way that you want them to ask, or they're not asking questions according to your arguments. So make sure you're not overconfident in any respect. Fourthly, know the basics of both law and fact. Now, there's a very famous saying in law. It's that if the law is not in your favor, then you should argue facts. And if the facts are not in your favor, then you should argue law. So you need to know the basics of both facts, which is the moot court proposition that you have at hand, and law, which is the statute or which is the constitutional provision that you will be dealing with. You have to have a very, very good command of this. At least the basics of it should be very clear. Right? Now, fifth, study your argument like the Bible. Again, as I said, whatever you have written, every single word, you should know it. You should know what point you are making. You should know what sub-issue you are making. You should know what is the aim of presenting this particular sub-issue before the judges. You should know all of that by heart. You are supposed to know it. See, the best thing about mooting is the fact that you get to take a lot of documents to the podium. Right? Even I am somebody who cannot speak by heart for a very long amount of time. I cannot do that. So the fact that you can carry your moot proposition, you can carry the constitution, you can carry bare acts, oral arguments, you name it, and you can carry it to the podium. So have that in your hand, study your argument very, very well, and present it also very, very well. Right? Then point to precedents. As I said, when the judges ask you a question, point to precedents, because the judge is more likely to trust a precedent than to trust what you are merely stating. Point to a previous judgment that has already been decided. Take the judge back to that. If you feel the judge is going round in circles, take the line of questioning back and point it to a precedent so that it's definitive in nature. Then use the opposing party's flaws tactfully. The opposing party, when they are making their submission, whether they are the petitioners or whether they are the respondents, what is going to happen is the judge will ask them questions. The questions that judges will be asking are the lacunae within those people's, or are the gaps within the other party's arguments. Note down those points. Note down the points on which judges are grilling them. Note down the points which they are not able to answer, because you will be using them for your rebuttals as well as when the judges are asking you questions, you're going to use those very points tactfully without showing down the other party. You are supposed to ensure and make the judge know that you have a better hand, or you have a better understanding of the law at hand than anybody else, right? And lastly, admit ignorance if required. A lot of times, as I said, we do not know the meaning of a word, or we do not know what the judge is asking, so on and so forth. So what we do is we just say whatever comes to our mind, or we pretend to know everything, and we sort of become overconfident. But if you do not know a particular issue, if you are not aware of something at hand, admit ignorance. Tell the bench that the counsel is not aware of the same. Of course, it's the last resort, but do it if it's needed, because it's much better than being overconfident and messing up everything. What's the worst that will happen is the judge will question you on a matter of law, you will not know it, and if you admit that you do not know it, the judge will merely come ahead and teach you what it speaks about. The judge will rarely cut your marks for this, because if it's a legal issue at hand, if it's a very complex legal issue, the judge knows that you are a student. So more often than not, if you've made a good argument, and if the judge knows that you know your basics and you're not able to tackle one or two questions, complex legal questions, the judge will help you. The judge will in fact teach you about it, and you will never forget it, because it is something that has happened in public, and you will remember it way too much for a very long period of time. Of course, do not mess up facts. Do not admit ignorance of facts, because that is a very very shameful thing to do on anybody's part. For instance, suppose you have got a court proposition about maritime law, and you do not know how many kilometers are in one nautical mile. That is that's a very very embarrassing thing to admit to the judge, that you do not know. So do not make those mistakes, do not make stupid mistakes. But yes, if it's a concept, it's a complex legal concept, and if you say that, my lord, the counsel is not aware of the same, then the judge will definitely guide you. Now, these are certain moot court competitions. Now, national as well as international moot court competitions. For instance, nationals mein there is GLS Ahmedabad, I am Nanavati moot court competition. There's MC Chagla, TS Venkateshwar Iyer, NLU Jodhpur, or Vidhi Pragati by NLU Delhi. Then for international moot court competitions, there is Philip C. Jessup, which is known as the World Cup of Moot Courts. There's ICC, which is the International Criminal Court Moot Court Competition. Nelson Mandela World Rights Competition, Stenson, Trilegal, etc. So that you can aim for. I would suggest, if you are a first time mooter, do not go ahead and take up any of these competitions first and foremost. Go ahead with a competition that is not going on for so long, and that is not so prestigious. Go ahead with a local competition, or a competition of your own city. Go ahead with that. Take an experience of the mooting, do one or two moot court competitions of a national level from other colleges, other universities, and then go for these much more prestigious competitions which have been going on for 50 years or 100 years, because the level of mooting and debating within these competitions is far wider and far broader than you would have ever anticipated. So if your very first moot court is this, it's very natural that you will get very intimidated. So go for a low-key competition first, and then after 2-3 moots, when you gain the confidence, when you gain the understanding of it, then you can always come up to these moots. And if you have already done 2-3 national moots, it's time to go ahead and try out some international moots now, because then that is a completely different criteria altogether. The experiences that you will have in a national moot are far different than what you will ever experience within the experience that you will have in an international moot is quite different than what you will have in a national moot. So keep that in mind. Now, if there are any questions, I would be happy to take them. Anybody, any questions? Right, so there's a question, how to structure an oral argument. Right, so when you've got an oral argument at hand, I can actually go ahead and present that to you. Just a moment. One second. Okay, I am not able to present the oral argument to you guys at the moment, but the way that you are supposed to basically structure an oral argument is at the start you are supposed to mention which case is it that you are, what is the name of the case, right? For an instance, it is Maneka Gandhi versus Union of India. So the counsel seeks permission to begin. Greetings to the bench. This is the counsel appearing on behalf of the petitioner in the instant matter, petitioner or respondent, whatever is your side. In the instant matter, Maneka Gandhi versus the Union of India. Then you go ahead and speak what are the issues that you will be dealing with. So the council 1 will be dealing with issues 1 and 2. Then you list down what are issues 1 and 2. Then you say that my co-counsel will be dealing with issues 2 and 3, or 3 and 4. Then the council will just get up and bow down before the bench. Then the other council sits down. Then you ask whether the bench requires a brief perusal of facts, which is nothing but a 1 minute compressed version of all the facts of the entire issue. You will list that down, and then eventually, seeking the permission of the court, you will begin by speaking your issue. The way that you frame the oral argument is the crux of the written submissions. You will use that and you will frame the oral argument and speak. Is there anything else? You can either drop it in the chat box or you can always unmute yourselves and ask me a question. No questions? All right. So if there are no questions, then I would like to end the session here, and I would like to go ahead and give the floor to Mika.